All right, so let's get this live going today. This one is very important without a doubt. So I appreciate you being here today. I've noticed my system has a slight delay. I've been working on with my tech team to solve this, and we'll get it fixed soon, I assure you. But I would ask that you listen to the content of today's live presentation. It's really valuable about why estate and tax attorneys distrust life insurance agents. And bear with me as I get my little tech audio delay issue here solved. So, but if you work as an estate planning attorney or a tax attorney, I want to start by asking you a very simple question. And I don't want a polite answer. I want an honest one. What has your experience been with life insurance agents? I'm asking because a close colleague of mine recently asked that exact question to a variety of estate and tax attorneys, and the response he got wasn't subtle. The person one time here recently literally rolled her eyes. There was no hesitation, no diplomacy, just a visible look of kind of disgust, followed by the words, "Not good at all. Agents are pushy and salesy." I've heard variations of that response more time than I can count, and I want to be very clear about something right up front. If I were in your position, I would feel the exact same way. First of all, this live is not going to defend the insurance industry. It's not going to explain why not all agents are like that. And it's definitely not going to try to convince you that insurance belongs in every estate plan. And a quick reminder, I apologize if there's a slight delay. My tech team's working on it. We'll get it solved soon. In fact, the core point I want to make today is this. Most estate and tax attorneys are right to distrust life insurance agents, and that distrust is typically earned. The problem isn't insurance. The problem is how, when, and why it's introduced. And until that distinction is made clearly, the eye roll is not only understandable, it's rational. So here's why what most attorneys experience over and over again. An insurance agent shows up, potentially late in the process. The estate plan is already drafted. Tax targets are already in motion. Decisions are already locked in. And then suddenly, insurance is introduced as a solution. Not as a part of architecture, not as part of sequencing, but as a product that's supposed to fix something that should have been designed upstream. That's not collaboration. That's interruption. And from your seat, it creates three immediate problems. First, it injects urgency when none existed. Second, it introduces a sales agenda into a planning conversation. And third, it puts you in the position of having to protect the client relationship from someone who may not even understand the broader structure. That's why the eye roll happens. And the insurance industry as a whole has done very little to earn its way out of that reaction. Now, here's the part that most agents never say out loud. Insurance fails most estate and tax planning conversations, not because it's a bad tool, but because it's almost always introduced at the wrong time. Insurance is typically brought into the conversation after the most important decisions have already been made, after asset allocation is set, after income strategy is defined, after estate documentations are drafted, after tax posture is largely locked in. At that point, insurance can only behave one of two ways. It can either be forced fit into a structure it wasn't designed for, or it can create friction by forcing changes that now feel disruptive. Neither outcome serves the client, and neither outcome makes you eager to work with another agent. This is where I want to slow the conversation down and be very explicit, because this is the real issue. Most insurance agents are not trained to think in terms of sequencing. They're trained to think in terms of products. They are rewarded for placement, not for restraint. They are taught to lead with illustrations, not with architecture. And they are rarely taught how to work inside a professional ecosystem where attorneys and tax advisors already have primary responsibility. So when they show up, they do exactly what they've been trained to do. They lead with a solution before fully understanding the structure. And from your perspective, that behavior is not just annoying, it's dangerous because it creates a cleanup work for you. It creates client confusion and it creates downstream problems that you're often left to solve again and again. If there's a delay, sorry that you just joined in my audio, forgive me, I'll get it figured out for the next one. I just ask that you listen because this one's important. So now let me be very clear about what I'm not saying. I'm not saying insurance never belongs in an estate plan. I'm not saying insurance is inherently bad. And I'm not saying attorneys should never involve an insurance professional. What I am saying is this. Insurance only works when it is introduced early, slowly, and with restraint. And that is almost never how it shows up. In well-designed planning, insurance is not always the strategy. It's sometimes a tool, and tools only work when they are used at the right moment, for the right reason, inside the right structure, with the right people doing the work. Most agents never get to that point because they don't know how. And more importantly, they don't know when not to sell. From an attorney's perspective, that's the real red flag. The problem isn't that agents talk about insurance. The problem is that they talk about it when it doesn't yet belong in the conversation. And that's where trust breaks. If you're an estate attorney and you've probably experienced this moment, you're reviewing a plan, everything technically works, and then an agent introduces insurance in a way that forces you to re-explain decisions the client already thought were settled. If you're a tax attorney, you've likely seen insurance introduced without regard to tax time, bracket compression, or downstream consequences, all in the name of getting something in place. That behavior is exactly why skepticism exists. And here's the irony. When insurance is actually appropriate, when it is introduced upstream, coordinated properly, and aligned with the client intent, it can be incredibly powerful. But most attorneys never get to see that version because the industry rarely practices it. So before we talk about when insurance belongs, we have to be honest about why it usually doesn't. And that's why I want to pause this kind of part one, because everything up to now is about acknowledging reality, naming the problem, and validating your experience, not arguing with it. And in part two of this live, I want to walk through exactly what insurance looks like when it is introduced correctly, using real concerns. And more importantly, I'll be very explicit about when it doesn't belong and when bringing someone like me in the conversation actually protects the client relationship instead of threatening it. And again, if you happen to just pop in, I know there's probably a delay with the audio. Forgive me, we're working on it. So now that we've been honest about why skepticism towards life insurance agents exists and why it's earned, I want to shift the conversation to something far more useful. I want to talk about what insurance actually looks like when it is introduced correctly, and just as importantly, when it absolutely does not belong in the conversation, because this is the distinction most agents never learn, and it's the distinction attorneys care about most. In well-designed planning, insurance is never the lead strategy. It's never the starting point, and it is never inevitable. Insurance only belongs after three things are clear. First, the client's intent. Second, the structural constraints of the plan. And third, the sequencing of decisions that preserve flexibility instead of eliminating them. When those things are not clear, introducing insurance early is not proactive, it's premature. So this is why most attorneys experience insurance as disruptive instead of helpful. So let me walk through what this looks like when done correctly, using real-world patterns rather than hypotheticals. I'll start with a case pattern that illustrates insurance as a tool of sequencing, not a product. a high net worth individual with significant qualified assets, strong income history, well-managed investments. On paper, everything looks solid. The issue is not performance. The issue was concentration. Too much of the client's balance sheet was sitting inside qualified money, which meant future tax exposure and loss of control, or would become unavoidable. In that situation, insurance wasn't introduced as something they needed. It was introduced as one of several modeled options to change the tax character of capital over time. The conversation did not start with premiums or policies. It started with structure. Only after modeling confirmed that insurance actually solved a sequencing problem did it belong in the discussion. That's what most agents never do. They skip modeling and go straight to illustrations. Now, let me contrast that with a different pattern, one that attorneys see far less often, but that matters just as much. A younger client with a significant net worth, not because they're near retirement, but maybe they've had a liquidity event or sustained success early. In these cases, insurance is often completely absent from the estate plan. Not because it was rejected, but because no one slowed down long enough to address it correctly. These clients are not resistant, they're cautious. They want to understand why something belongs before agreeing to it. When insurance is introduced in these cases, it must be framed as infrastructure, not as protection, as architecture, not as a purchase. Again, insurance is not inevitable. It earns its place by solving a specific structural problem. Now, consider a very different scenario, a ultra high net worth individual, significant estate exposure, complex family dynamics, sophisticated advisors already involved. In these cases, the absence of insurance can be just as problematic as the misuse of it. But even here, restraint matters. Insurance does not belong until health issues are understood, estate objectives are clarified, and the role of insurance inside of a broader plan is defined. Rushing that conversation, even when the numbers are large, destroys trust instantly. What all these cases have in common is this: insurance belongs only after architecture is clear, and architecture is not something most agents are trained to think about. This is why attorneys distrust insurance professionals. Not because insurance is useless, but because it's usually introduced without respect for sequencing. So let's be very explicit about when insurance does belong. And again, if you just joined or you popped in late, I'm aware of a little audio delay. Forgive me, we'll get it cleared up probably in my next live. Insurance does not belong when it is being used to patch bad planning. It does not belong when it's introduced to create urgency. It does not belong when it bypasses tax and estate counsel. It does not belong when it forces changes to documents that were thoughtfully designed. And it absolutely does not belong when the agent cannot articulate what problem is being solved beyond getting coverage in place. Now, let's talk about when it actually makes sense to bring someone like me into the conversation. Not because I sell insurance, but because I think in terms of sequencing, restraint, and coordination. If you're working with the client and you notice that insurance keeps coming up as an idea, but you're uncomfortable with how it's being framed, that's a signal. If you see a client with a significant estate exposure and no insurance, and no one has slowed down long enough to model whether it belongs, that's a signal. If insurance is being proposed and you're thinking, this feels premature, that's a signal. Those are not moments to implement, they are moments to pause. They are moments to model options before committing to a path. That is where collaboration adds value, not by selling, but by protecting the structure and preserving flexibility. The process I use always starts the same way. We identify whether insurance belongs at all. If the answer is no, we stop. If the answer might be yes, we slow down. We clarify client intent, we model alternatives, we pressure test assumptions. Only then does insurance earn a place in the conversation. That process protects you, it protects the client, and it removes the very behavior that caused the eye roll in the first place. Now, if you're an estate planning attorney or a tax attorney and you want a simple one-page checklist that outlines when life insurance belongs in estate planning and when it doesn't, just comment checklist below. I'll send it to you directly. And if you ever want to compare notes on a case, no pitch, no pressure, I'm always open to a professional conversation. Thanks for spending part of your day with me.